Hi guys, this is Rob Lambert with AssetProtectionTraining.com. Today I'm going to be going over a short tip which you can use to protect your inheritance. It's a very powerful tool. It turns a lousy estate planning trust into the equivalent of a $25,000 domestic asset protection trust. All you have to do is have the courage to bug your parents about your inheritance. Let me explain it to you. This is a typical estate planning trust. Note, we've got this blue and red thing down here. That's a trust. It's loaded up with money. This money sign just means it has assets that you're going to inherit from your parents. This is the type of trust that most people with any significant wealth will almost always do. Why? Because it avoids probate. This is a revocable trust. It allows sophisticated tax planning, but in most cases it has no asset protection benefits at all. Normally the players in this are the settlor. That'll be your mom and dad usually, and it can be somebody else, but for this example I'm assuming your mom and dad are leaving you some money. The trustee is also normally your mom and your dad. It's in the United States. It's not protected. It's easy for creditors of your mom and dad to get to. And down here is the beneficiary. This little blue guy is the beneficiary. This blue guy is you. The red guys are your mom and dad. And for the purposes of this example, that's very, very important. Well, let's talk about it. This trust allows your mom and dad to save some taxes. It allows you to get their stuff. It allows you to get their stuff without going through probate. Nobody knows what you got. It's a very wonderful tool, but most estate planners just assume it has zero asset protection benefits. Let me explain why. There are two reasons why domestic revocable living trusts are nearly worthless for asset protection purposes. The first of these reasons is the self-settled trust rules. Well, what are the self-settled trust rules? The self-settled rules mean that the grantors of a domestic revocable asset protection trust cannot take advantage of the spendthrift provisions that are in almost all of those trusts. The spendthrift provisions in each of those trusts are valid in all 50 states. And what those spendthrift provisions do, and there's several videos on this and links below, but those provisions keep creditors of a beneficiary from forcing the trust to disgorge assets. I once had a situation in San Diego where a young man was the beneficiary of a very, very substantial trust, many millions of dollars. His dad had just died. He's a very wealthy man. He's going to receive some very substantial distributions from this trust. He went down to the local Ferrari dealer and talked some stupid salesman into giving him a car on a promise that he was going to buy it and that the trust was going to pay for it. And he proved the assets in the trust, and he proved that he was the beneficiary. They gave him the car. Well, the trustee said, no way am I spending in this case, my brother's money to give you a $400 and some thousand car. No way. The Ferrari dealer had to take it back. He could not force the trust to pay for this car that the beneficiary so ill-advisedly purchased. The self-settled trust rules only apply when you did not settle the trust. If you settle the trust, they are worthless. That is why domestic asset protection is nearly always unreliable in the United States. The self-settled trust rules specifically state in every state, except the ones that have recently enacted asset protection regulations, that the creditors of a beneficiary of that trust cannot grab the trust assets. That's the first one. Second one, the full faith and credit clause of the Constitution. This clause provides that all 50 states can enforce their judgments in all the other states. All you have to do is register a judgment. You do not have to relitigate it. And the states that have enacted domestic asset protection legislation forget the full faith and credit clause. They pretend that it doesn't exist. Well, they're all wrong. And that's why domestic asset protection trusts are absolutely malpractice to do right now, because they've never been tested. And if the U.S. Constitution trumps domestic state law, which it always does, then those domestic asset protection trust laws are irrelevant. Watch my videos on that. Well, so what we have is a domestic trust that is of little or no effect to protect the assets in the trust. But there's one simple tip to turn that nearly worthless revocable living trust into an effective asset protection trust. What is it? Look at it. Here we have the trust. Here we have the mom and dad as trustee. Here we have the mom and dad as settlor. Here we have you as the beneficiary. What you do is you do not take a distribution. What do most parents do? Oh, hell, they spend hours talking to the estate planner about when the kids are going to get the money. Do they need to be 25? Do they need to be 30? Do they need to be 35? When are they going to be old enough to become millionaires? When won't they snort it up their nose? Well, guys, don't go that route. Leave the money in the trust. Don't take the distribution. Instead, you as the beneficiary here should become the trustee instead of taking a distribution. Let's see what that looks like. See, we got you, the beneficiary, trading places with mom and dad. When mom and dad think that you're smart enough to inherit $1 million or $100 million, and they say that's 35, well then when you're 35, they should resign as trustee and make you, who's also the beneficiary, the trustee. Then your trust will look like this. You will be the trustee. The beneficiaries will remain the same. But look, mom and dad, this little red thing, that's mom and dad, have been removed as trustee. They once were up here. They are no longer up there. Instead, they're removed. They're onlookers. They have given you the power to control the money that you inherited. And that gives you the power to spend the money, to do anything you want to with it. But look, what you have here is a non-self-settled trust. You are the beneficiary of a non-self-settled trust. That means that in all 50 states, the spendthrift clauses apply. They work because it's a non-self-settled trust. So, take this with you. I wouldn't even have a job if everybody did this. If you were going to inherit money and you convinced your parents to always make you the trustee rather than giving you the money all outright so that you could put it into a trust and have a self-settled trust, that's not good asset protection. It's much better to say you become the trustee, take over the management of your own money, and you can do with it as you please, but you still can hide behind the spendthrift provision and protect yourself from